Okay, my name is Martine Courant-Rife, and this is a short little tutorial on copyright issues for professional writers. And my credentials are that I have a law degree and I also have a PhD in rhetoric and writing with a concentration in intellectual property and technical communication. And my dissertation actually was about how copyright does or doesn't influence digital composing. If something is original and fixed under U.S. law, and everything I'm going to talk about is U.S. law, but if an artifact or text is original and fixed, then it's copyright protected. You can get a lot of information about copyright at copyright.gov, and this is the section of Title 17 which defines what copyright covers. That gives kind of a list. Literary works, musical works, dramatic works, pictorial, graphic, sculptural works, motion picture, sound recording, architectural works. So any kind of traditional text, anything at all which is fixed in a tangible medium of expression, and it has to be original. So, a red circle is not original. It's just a red circle. So, if somebody drew a picture of a red circle and then decided that if the next person drew a picture of a red circle, they were copyright infringing, that wouldn't work under the law. Let's be clear then. Images, text, sounds that you find on the web are probably very highly likely copyright protected. So when you use those, then legal issues arise. Whether you want to acknowledge that or not, those issues are present. There's two kinds of use you will make of others' copyright protected materials, and these are the same kind of uses which other people will make of your copyright protected materials as well. I talk about that in a different tutorial. So the two kinds of uses you can potentially make of anyone else's copyrighted materials are an authorized use or an unauthorized use. If it's an authorized use, it means that they've given you some kind of permission, written, oral, they've given you a license, or you're using it under Creative Commons license, or you got it off Flickr and the license on Flickr says you're allowed to use it in this way, this kind of thing. License literally means permission, so that's what it means. And you don't have to use Creative Commons. With respect to your own work, you can write your own license as well. Okay, the other kind of use you can make of someone else's material is unauthorized, which means you don't have permission. And to do this legally, for the most part, you have to be within what's called fair use, which is defined under Section 107, and I talk about that in a different tutorial. So your other choice of using unauthorized is to use it illegally, which people do. I mean, from my dissertation research, people think that sometimes their use is copyright illegal, but they do it anyway because they think they won't get caught, or they think the law is wrong. So that's, I'm not going to make any judgments in this tutorial, but that's the issue in that case isn't whether or not it should be a fair use, but the issue is that it's probably not a fair use, but you're not going to get caught. So it's kind of important to see the distinction between using authorized and using unauthorized, and the two different ways you can use unauthorized, because these kind of discussions, you'll see people talking about them and they get really confused. Okay, with respect to your work, it's automatically copyright protected once it's fixed. If you do nothing, so say you create a web design, a web page, a blog or something, and you've got original text in there and designs and so forth, if you do nothing, it's protected. I mean, legally, can someone go and take your stuff? Well, yeah, of course. You can legally include the copyright symbol if you like. You don't have to register anything in order to use the symbol. If you want people to use your materials, so let's say you create something, you want everyone to read it, you want them to take pieces of it and incorporate it into their work, you can either write your own permission language from scratch or use something already written by Creative Commons, or you can, construct a document so that people are just attracted to it and they want to take it and use it. And that's some of the work being done by Jim Rodolfo on rhetorical velocity, where in an activist setting you want, like, major newspapers to pick up your events, so you do press releases and so forth using language that is very attractive to big media, and that's a whole different issue. So, but if you're doing it in the copyright frame and you want to encourage people to use your materials, then you can just say that in some way on the document itself, or you can adopt a Creative Commons license. If you want to formally register your work, copyright.gov provides directions. I have never actually gone through this process, but I think it's fairly straightforward. Right now the fee is $35, but they do tend to raise the fee every once in a while. If you want to sue somebody, you have to have your material registered. If you think there will be a chance that someone might argue that they created something similar to your work before you did, you might want to copyright your work as a method of documentation. I do want to say, though, that two people can create things that are substantially similar, but if they did that independently of each other without knowledge, that means that it's potentially not, neither one is copyright infringed. So it's not like patent where only one person can have this particular design or whatever. But as I say in the final bullet here, one can be deemed to have infringed on a copyright work of another if it is substantially similar and the creator had access to the original work. So the famous case is a case involving George Harrison and a tune by the Chiffons, He's So Fine, and George Harrison's song My Sweet Lord. There was a case where it was alleged that George Harrison's My Sweet Lord infringed on He's So Fine, and during testimony, Harrison said that he didn't copy from He's So Fine at all, but when he was growing up, he had listened to the Chiffons tune many times, and so because the songs were so similar, they were substantially similar, the court determined, and because George Harrison had access to that previous music, the court determined that there was copyright infringement. So the thing with copyright infringement is you can do it without any intent whatsoever, which is kind of frightening. So if you been looking at 10 famous web designers' web designs and you've kind of internalized that, and then years have gone by and then you created a design that is substantially similar and is very, very unique, that previous creator could come and say that you had infringed on their copyright, and their argument would be that you had seen their copyrighted material and you had been influenced by it. So those kind of things don't happen very often, though, so I wouldn't be worried about it too much. Okay, but if there's an issue that you feel like you really need to, that there's other things going on around you, that someone might argue that they copyrighted that their material came first and they had the idea first, then you might want to copyright your material. Two issues of use under U.S. copyright law is, number one, and this is what I referred to earlier, is it legal? And number two, if not, is it ethical when you get caught? Okay, I'm not advising people to go around breaking the law, but I know from my dissertation research that people do break the law because they think the law is ridiculous. So that's, I'm not preaching one way or another, but these are two separate issues and they tend to get confused a lot, and that's why I'm trying to draw them out. So is it legal, and you have both authorized legal use and unauthorized legal use. Both those types of uses can potentially be legal. Unauthorized use is potentially legal if it's fair use. Okay, if it's not legal, okay, say that this was something that came up in my research. Someone hacks into a DVD to get movie clips out to do some kind of a cultural critique. Well, the DMCA, the Digital Millennium Copyright Act, says that you're not supposed to hack into DVDs. That I think it's a felony or something. And this person that had done this knew that that was not legal, but did it anyway because they thought the law was ridiculous, and they wanted to be able to make this political statement about certain aspects of this movie that was on the DVD, and the only way that they could do that was to break the law. So, I mean, you have to. One of my research participants said, "What would we do if Rosa Parks had, not refused to move her seat or whatever?" So sometimes laws are broken because people don't think that the laws are correct. Again, I'm not a proponent of breaking the law. I'm just saying that it's good to separate out the issues and to know about one's own behavior, whether you're doing it because you think the law is wrong as kind of civil disobedience, or if you just don't know what the law is. So